the Registrar of the High Court, Honorable Judy Omange, is with us in studio this morning. Good morning.
Good morning.
Karibu sana.
Asante.
Thank you for joining us. Just jumping right into this conversation, access to justice has been, clearly the mandate, especially now more pronounced by the Chief Justice when she took office a year and some months ago. And obviously, succession matters fall into this, that the access to justice cannot really be full access to justice without succession matters being brought into the conversation. Can you give us an overview of, what we are looking at when we're talking about some of these succession matters? What are some of the delicacies that you had to deal with on a regular?
Okay. Thank you very much. And I'm very happy to be here to just talk about succession matters. Let me start by saying succession matters involve all of us because it's about what happens when we are no longer there to take care of our estates. And the last I checked, none of us is really living here alive. Basically, it means everybody will at one point have a succession matter in court if you have any estate. Now, there are issues. The main issues around succession matters are that first, many of our people don't know about the whole process. So you find that when someone has died, people didn't know what property he had in the first place. And if they didn't know who are his or her beneficiaries, meaning who are, if you're a man or a woman, who are your children who are entitled to inherit from you. And then, of course, you didn't order your affairs in the sense that you didn't say how your property will be disposed of. So people end up in court for those matters to be resolved. If they know, some don't at all, so their properties are unadministered and cannot be used once they pass on, unfortunately. But those who end up in court, it's the best case scenario is that they all agree, which is quite a number that they agree. But we have a huge percentage where families don't agree, unfortunately, on how the wealth will be distributed. So these matters end up clogging the courts. Some of our oldest matters in the courts, in the judiciary, are from succession matters. Because families have fought, they left the fight to grandchildren to fight, so it's a continuous fight. So this week is about, first of all, educating our court users and just the public about succession matters and the importance of concluding them well. But it's also about accelerating the ones which are already in court. So we have 2,500 cases that are going to come up for closure in the next week. That is where people are not contesting. They just want the court to finish their matters and give a decision. So those will be accelerated next week in service week from 1st to 5th. Then there are a whole huge percentage of around 6,500 cases where parties have not even come to court. They got what is called an initial grant, meaning you're given just the letter saying you're the one who should administer this estate. But it has not been distributed. They've not come back to court for the court to now say, you get the house, you get the car, you get the property in at home, you get the one in town, like that. So those ones, we are going to issue notices to the parties informing them they should come to court and have those cases finalized. And then there's a category, around 900, where are seriously contested, we are sending to mediation. We are hoping they'll be able to now agree with the help of a mediator on how these matters can be determined. So that's the different approaches we are using to solve some of these cases next week.
You mentioned something that, first of all, thank you for coming to the show.
Yes.
There are certain issues you say which are not contested, and some are contested. Could you expand on this a little bit?
Yes. So the ones which are not contested, it means we are all in agreement. If we lost a loved one, they have left property, we are all in agreement. You take the car, you take the house, you take the house in shags,
You take the debts.
Yeah, yes. You take by the way, that is also something that is up for discussion. You take the debts. We are all in agreement. And we are saying, all of us, you are the child, you are the wife, everybody agrees. That is the best case scenario. But then there are others, these contested ones, there's serious dispute. First, it's even a dispute of, are you a child? Are you even a wife? You know, really, before you even...
Others who are not known come.
Yes, and then others show up.
Yes.
Yes. So we are saying, can we go for a DNA?
Yeah.
Can we confirm it is you? You know, like that. So those are the contested ones, and now the courts have to intervene and help.
And sometimes it goes to the stage where, Honorable Omange, that people cannot be buried.
Yes.
People are waiting for children to go to school because these cases are waiting for adjudication. Some land is held somewhere. Somebody wanted to sell proceeds from an orchard that is on said land. They cannot touch, So when the court looks at those issues, what then would be the decision of the court when the life or the progression of life of somebody else hangs in the balance when this succession case is still pending?
Yes, unfortunately, many many of us still believe that if you bury somebody, then you have the right to inherit their property, which is not the truth. Burial is a totally different issue. Burial is totally different. But the courts now, when faced with such a situation, would of course first of all look at the wishes of the deceased. And this is where we can also help. If you just know in our place, you have something, you say, this is my boma and it's an official thing. Then people know now this is your home. But if you didn't make your wishes clear, the court will try to find out what would have your wishes been. In some instances, like the famous case we dealt with of SM Otieno, now they looked at the culture, of the people. That was now the determination. So the courts will resolve that issue, but it is not connected to inheritance, whether you will take the property. But our people believe that if I bury him, that means I'm the wife. Now no one can come and say
and Honorable Mange, you've talked about culture, and there have been so many legal reforms, but there still seems to be a clash between culture and law. And you rightly said earlier that there is lack of awareness. To what extent is this culture still a barrier, and how is it relating with the law? Because in many communities, they're likely to tell you if a certain person passed on, the widow in that homestead has nothing. The in-laws come inherit. Some even chase away the widow. So it's a clash between culture and law. How are you dealing with that?
Okay, we are all a product of the various cultures we come from, and I think that is something to be admired and even in its proper place to be respected. But when it comes to the law, we say it should not be repugnant to morality, justice and morality. Meaning we cannot enforce a culture which is going against the law. That will not be acceptable. We can also not enforce a culture that is going against something, morality really. What is just moral? As human beings, even if something is not in the law, we know what is right
and what is wrong.
And what is wrong. So the court will not enforce that. But if it is something which is not really harming anybody, it's not against the law, and it is accepted, then I think the courts would help it find its place.
This number of 2,500 now, which will be expedited over the next 1 week, like as you said, if they were ready to have a chat, because basically that's what it is, that they're ready to discuss and say, okay, let's let this one go. If it was, and I'm going to say careful, quote unquote, so easy to have them make that decision, why then was it not easy to do it in the first place before they brought it into the court system?
Okay. Yeah, because the law as it is says that it is the court which must make that decision.
Okay.
You can't agree and then that order that agreement be used outside of the court premises. Okay. But if you agree, it's actually an administrative process. It's very simple. You just fill a form. You say there's there's an application called for confirmation of grant and distribution of the estate. We're supported by a distribution of the estate. Just say this is how we're distributing our estate. When you come, the court's only business will be to say, are you all in agreement? You are here, you are there, you've all agreed. This is what you're saying is true. Then we pass it. So we don't even have any, really, now the court does not have a role in contesting that.
Okay. Now these 900 that are heavily disputed. We read on a daily, we're consuming this information about people who've been in court for 40 years, people who were born at the time that these disputes began, have grandchildren today. why has it been then so difficult to get them through the system and then, rule on a matter or have it settled?
Yeah. You find when there is a contest, it's usually more of an emotional issue and than a legal issue. I used to work in the children's court, and there you'd find very emotional disputes coming before you. People really, having, you're just believing it's not because you have really a legal basis, but it's more of a, like now, if I discover my husband had, a wife outside or two, and then it's coming up after he has died, you're now dealing with that. It's very emotional. So we are now dealing with those emotions. So you're saying, no, she's not entitled because really, I didn't know about her. So really, we are dealing with a lot of real human issues that the court is now being asked to process. And you see, the court cannot really deal with those human issues. It is these parties who must one day now reconcile themselves to the fact that this happened. How do we move forward? These children were my husband's children. Honestly, they didn't do anything. They deserve this estate. So that is what the courts have been trying to process using legal means, but we have found it doesn't work as well. And that's why mediation has been most successful in family matters. The statistics for mediation since it started in 2016, we've been able to clear 3,500 cases through mediation on family matters. The ones which have been resolved have a net worth of 5.2 billion. You can imagine. Yes. A success story, a 1987 case, which had taken 31 years in court, 31, was resolved.
So people died even before this thing was resolved. Yes.
31 years was resolved in 2018 within 41 days. They just went to mediation. After 41 days, they resolved it. So you can imagine.
Something comes to mind.
Yeah.
This matter of culture and the law. Our current laws do not distinguish between whether the children are female or male when it comes to inheritance. If I'm wrong, correct me, because I'm definitely not a lawyer. Okay, and I could have wrong the wrong chapter of a constitution of another country, and I'm thinking it's Kenya. Now, many traditions haven't moved from that position they had before, where women, especially if they had been married, didn't have any rights to any property in the ancestral home that they originally came from. Now, when such matters come to you, now, is it something that the courts would readily deal with, or would they now take it to arbitration almost immediately?
Okay, we start from the premise all children are entitled. So the children, if you're a child, whether you're a lady or a gentleman, you are entitled. We give you the chance to agree. If you agree as a family that, the daughter, we're going to give you the money in the bank, this ancestral home, because you're not here, we are taking it elsewhere, we're giving the men, that's fine, we'll go by that. But if you ask the court to agree, to resolve that dispute, then you're likely to have a case where they share the property equally.
I mentioned this is because the assumption that the lady is already married. What if that marriage doesn't work?
That's true.
It reminds me of a case. I was involved in producing a documentary on land issues in Western Kenya with a certain NGO. Actually, Roots Kenya, they're quite involved in raising awareness on these issues.
We had them
I saw them yesterday.
Yes.
Frida, you are with the Frida. Yes, I was with Frida. So we did that. We were producing a document. So I'm in a certain homestead with my videographer and someone from Roots conducting the interview. We saw pangas. Stop. What saved the situation is they know me, Chamada. So it's like, yo, Chamada, we know you, but stop what you are doing. Yeah. It was a case of the same thing. That a lady was coming to claim her rights. There were their rights in that homestead. They were married. But their in-laws were saying, no, you have land where you went. You can't have land there and have land here. So it's quite a big issue. Yeah. But I would use this to just ask another question related to this. Who are the key players who can help out in solving these matters apart from the judiciary? we know chiefs play quite a big role in this matter, but who are the key players, whether government, non-governmental?
Okay. So the key players in managing succession cases, mainly they are forms you fill, and they are the only category of cases where you just have forms to fill. So anybody, if you have the right information, you can fill the forms. But again, the issue of knowledge is a problem. Then they come to the courts. We gazette them. I'm the principal registrar, meaning all matters in succession matters across the country are brought to a registry that I run to confirm whether there's another one. So once we confirm there's no other, we issue with a form, and it is gazetted in the government printers. The government printers is, of course, we know the government printers. They have a gazette notice where they put all the cases. So I think you've seen those cases. Yeah. They appear in one schedule. We agreed with them. They will be publishing them maybe twice a month in one gazette notice. So the government printer is a stakeholder. But after that, you come back to court. We issue with the grant. After 6 months, you come for confirmation. So this confirmation bit is the one many people don't come. These over 6,000 cases are in that category because they just came, they got the initial grant, they went and maybe thought this is enough, and maybe somehow they were even allowed to access the estate, which is wrong. Because you see, if you have a letter of administration, you can access the estate, but not for the benefit of everyone else. So once you get that letter of administration, now we are putting in them, we have come up with the Chief Justice has come up with new guidelines where we indicate this grant should not be used to distribute the estate. So now all parties will not be able to use that. You'll have to now come back where now we give everybody their share, whether they are married or not. Yes.
Is that the aim, that everybody is happy?
Yes.
Or is the aim that the person who has, brought this case before the court, then either be satisfied, or are you saying that now, because succession usually is not just one person, very unlikely that a sole child, for example, of the father is going to go fight with anybody, unless of course you have wife, spousal issues there. But I mean, if you have siblings and such, so is the goal of the court to essentially make sure that everybody is happy or satisfied?
The goal of the court is to ensure that the property of the deceased is used in a way that everybody who was dependent on him benefits from it. Okay. So we do not want it just to be administered that you've taken it, now you've gone and used the grant alone, so you're happy yourself. We are concerned about those others, the many others whom you're coming on behalf of to court. That's why in this confirmation process, they all come. All the dependents come to court, or at least nowadays they come virtually. You don't have to physically come to court. And we see you and we say, the judge sees you and says, okay, everything is ready. This is how we're going to distribute the estate, and that happens.
Okay. In the case of children, unfortunately, a lot of times when we see that one, usually, unfortunately, if the male, the man has died, and then a few days to the funeral, somebody comes along and says, actually, this is the father. He was the father of this child. Yeah. Does the court take into consideration knowledge by the community at large that they knew or did not know of this child? Because we've had, like we said before, funerals stopped, estates cannot be accessed, things cannot happen because, somebody has come along and said he was the father of this child.
Yes, the courts will be looking at what evidence would be to show that this child is the deceased. One of the evidence, of course, could be people just testifying. I used to see this man going with shopping, but there's also scientific evidence now.
Careful where you go with shopping, sis.
Yes, I used to see this man. I used to see him even taking this child to school, attending board meetings. Those are things the court would consider. But of course, the scientific evidence would carry the day. The DNA and even the birth certificate to some extent. Because if your name is in a birth certificate, that also, it's part of the evidence. And you remember, the burden the court looks at here is not absolute. It's not like in criminal, where we're saying it's beyond reasonable doubt. Here we're looking on a balance of probabilities. Is it possible? Is it not?
There's something that Alex mentioned. In many traditional settings, you will find that most people aren't even aware of these court processes where these matters can be resolved. A man dies and the widow is left with the vagaries of his brothers and cousins and the village mates. And usually the widow suffers immensely. Now, I know that the are very many processes that the judicial system has set in place to reach even these people who are not easily reachable. Now, the success rate of this, I'm not going to ask about, but I'm going to ask this. Because, again, it's now tradition being used adversely to disadvantage somebody who probably doesn't have the power to fight back. What exactly does the court do in relation to, say, for instance, NGOs that deal with this sort of thing? I'm asking this because I know of NGOs. I know of a specific one called Kellen that has dealt a great deal with inheritance issues. And also with this very same thing that we're discussing here. Is there a way in which the judicial system, as we know it, works in conjunction with some of these other players to ensure that justice is actually provided for people who may not necessarily have access to our courts?
That's very, very good. In fact, Kellen has been one of our greatest partners. Yes. In the family division, they helped us with a lot to develop a lot of IEC materials, just saying, like, if you want to file a case, what do you do? Which can be used to educate the public. And next week, as we have that week, we are giving all our stations the materials that we developed with Kellen. So that is what they will be using to educate those who visit the stations, just to tell them this is what happens in a succession matter. But we're also very glad if we can get other players as well, like the media now, to help us tell that story. Yes, because a lot of it is about not lack of information. Yeah. So I think we are very glad about that, having that space. Yeah. Okay. Yeah. There was a question, sorry, Alex asked about other key players that are not reached. The public trustee is a key player. And that one is important because sometimes there's no one totally to administer the estate. They come in on board, especially if like children were left. There's a time when many children were being orphaned very young. Yes. They would come and file on their behalf. So they are very, very key stakeholders. Yes.
All right. Let's take a break and take a look at weather and traffic and business news. And then we'll come back. We are in the studio today with Honorable Judy Omange, and we're looking at succession in terms of the court judicial process and expediting a lot of those cases that are in the courts today. It's 28 minutes to 10 o'clock. The conversation continues after this.
This is the Situation Room, the only way to start your day.
Alex Chamwada, who's our guest host for today, and the Honorable Judy Omange, who is the Registrar at the High Court, and asking ourselves questions today, really opening up this conversation about succession judgments in the country and the adjudication of them. Going into this week from the 1st to the 5th of August, Honorable Omange, why was the decision taken to focus specifically on this?
Okay. Yes, the Chief Justice has launched a blueprint called Social Transformation Through Access to Justice. And basically it's about, as we access justice, can we also bring about social transformation? And this week, the focus on succession matters is number one, because we just want to expedite the hearing of these matters for a very, very crucial category of court users. You know, we are going into the season where we're going to have a lot of other matters competing for the court's attention. And we thought, let's just clear with these ones which are ready so they don't have to wait until we clear with the other matters which we are now going into as a country. But then also it's about bringing into focus issues of succession matters, because when you dedicate a week solely to succession matters, as judicial officers, judges, we are reflecting on how we are managing these cases and how can we do better, how can we improve them better, how we are managing them. And this is especially in light of recent directions that the Honorable Chief Justice has given on succession matters. And then it's also about educating the public, really. That's what we are hoping that will happen in a lot of our stations, because as we have said, lack of knowledge or information has opened up this area to a lot of people who take advantage of people. Of innocent people who don't know. Because you don't know that you can just file a form. Maybe you're giving someone money to file for you. Because you don't, it's true, because you don't know how to get information on your case. You're there, asking a different person to come to court on your behalf, and they're not even giving you the information so that they can keep on taking money from you. So it's about just opening up and alerting our court users about some of the issues around this and what we are doing about them.
It's part of awareness. And then what can be done about affording justice? Because for the families to handle matters, you need to afford a lawyer. Not so many can afford a lawyer. That's a quagmire. The services of a lawyer, even just the thought of going to, we see it as it being elitist.
Actually, in the succession matters, you really don't even need a lawyer. You if you're not contesting, if you're all agreeing how the property will be shared, you just need to fill those forms, and then it's an administrative process. Like I said, it only gets to the judge the day you're going to confirm. So if you are able, and those forms are self-explanatory, like you can be able to fill them for yourselves. I think it's more of information on how to get that information that is a problem. But it's one where you can do very easily without a lawyer. But if you do need a lawyer, there are quite a number of NGOs, I think, like we have mentioned, which are able to give support in that area.
But you see, where you don't need a lawyer is where you agree.
Yes, where you agree.
Maybe that this brother, the sister are fighting. They need lawyers. That's different.
Now where there's a fight, then you might need a lawyer. But even then, very many people come to court without lawyers. We see succession matters. You find many people just come and say, no, I don't think they should get this estate because of ABCD. And you see, you'll be asked by the court to give your evidence, and they give it, and then the court makes a determination.
So now educators, educators, when we talk about succession and all these challenges, is it just about land and property? Are there other areas? I'm not an expert.
It's mainly land and property, but anything that a deceased person has left behind. Because once you immediately, someone dies, even your phone, you can't, unless your wife knew your M-Pesa line, your M-Pesa PIN, which many people don't even share. So, even your phone, for you to go to Safaricom and get that money that is in the phone is a problem. So everything is up for discussion. Everything is up for distribution. The bank.
Mentioned, in fact, you've actually gone to where I was going, the bank. I remember having a conversation with one of my bank managers, and she was expressing something she had struggled with, and struggled because there was nothing she could do. A client dies, has a lot of money in the bank. The wife is not aware. But the wife is also an account holder. And so the wife comes and she was saying the struggle was, I know how much money this person has, but I cannot tell the wife. And the facility the wife is seeking, I also cannot give because she doesn't qualify. And yet, I know.
Were they joint bank account holders?
The joint account is the one which didn't have money. Okay? The wife herself had her own account. But this gentleman had many other accounts because he was a businessman. And the accounts had lots of money. But the wife was not a signatory. Now, what happens in cases where the family doesn't know what somebody owns and they pass away? Is there a law that allows them to know at some point what was what the person had? Because or does this money go to one of these government agencies that keeps what are they called, unclaimed assets and so forth,
unclaimed financial assets?
Yes, those ones. Yes. And when it goes there, then what do they do? Does the family ever get to a point where they can benefit from some of these things?
Unfortunately, that's now the problem. Like we started by saying that if you don't tell your wife what you own, it's actually a product. It's a case for going to the unclaimed financial assets. And once it goes there, they're holding billions. Actually, they're holding billions.
They told us,
They told you that.
Yes,
they did.
They're holding billions. So you can imagine, it's because we are not open about what we own. We should have at least that friend who, even if you don't trust your wife, that friend, but I can, because if you can imagine, if you had a joint account, okay, even I don't have one, but if you had a joint account which was operational by both of you.
Do not worry, you're not alone.
Maybe you have one. So if you have a joint account where each of you can operate it, you see, even if your wife or your husband dies, then they can be able to now continue with it. There is no problem. And even the property, there's a way you can own your property jointly, so that now even if one of you dies, the other one now, it goes automatically to you in an ideal world. But because it's not an ideal world, we should ensure that property someone knows, someone who can come, at least a friend. Because otherwise, of course, the government eventually we will benefit from it as the people of Kenya. Because eventually, I think Unclaimed will give us those assets.
You know, the reason why I'm asking this, it goes even beyond that. Because, for instance, you have absentee landlords, people who've owned land, property, maybe they traveled abroad, they never came back, and those things now, again, revert to the state. Now, the question I'm asking is, are you saying we do not have a law which doesn't find a way of letting the family benefit? Because you know the individual, you even know who the family members are.
Oh, so that now they, like in your case, the bank would now become allowed
to disclose.
I think maybe that's one of the things we can look at in terms of changing our legal regime.
Because it isn't that it isn't a pointer to anything negative that they were probably not getting along. It's just the way African men function. Yes. They keep very many things to themselves, just like they keep second and third wives to themselves until the day they die. Because they fear the first wives. Yes, you dare not. Yes. But the point is, shouldn't there be a way of getting the family to benefit from this?
If the end goal, like you said, Justice Omange, is to say at the end, what we are trying to do is make sure that this estate will benefit all parties involved. Because here we are looking at a situation where, I mean, and they did tell us that unclaimed assets, unfortunately, the majority of cases of unclaimed assets, people who have died, you know, and the law precludes them from then sharing this money until all the documentation is in order.
Yes.
Now, isn't there a way to, avoid such a situation in the future by amending so that it allows that in the case of death and there was no previous, sharing of this information, that then the law can step in to say, should you prove that you are actually the, children and spouse of said individual, that then this property, this estate, these funds can then go towards the end goal of the judiciary in the first place.
Actually, that would be it's a good end goal. And even now, the unclaimed financial assets, they're working very closely with us in the judiciary to help us try and tie the knots towards some of these, tracing some of these properties. But even a better way of doing it would be to compel anybody who has access to such an estate to declare it. If they know someone has died, they're the ones who now are declaring it without waiting for the widow to come. Of course, that's presupposing they know someone has died. Because you could be in a case like, in the bank, they might not know. This one, maybe your case,
the case I was being told of.
That one they knew.
They knew.
Yes.
Because those two used to come to the bank together.
Yeah.
But the manager also knew that this man has accounts. But what they didn't know was the wife had no knowledge.
And they have a confidentiality
They cannot.
clause.
They
as
cannot
a customer, you have a confidentiality clause. The bank cannot reveal your information. So I think that is what we can look at, especially in the banking industry.
Yes.
Can that law be amended so that once somebody has passed on, the bank manager can now disclose to their nearest people they know about that? I think that would really be a way forward.
What was also niggling in the back of my mind was, say someone dies and leaves, we're talking of estate. The estate they leave is in the negative, is in the red. They leave debts.
They leave debts, yeah.
Yes. Now, if the family is not known, so it means whoever they owed money, well, too bad. Or is it? The point is, no. People who are owed money don't let things go like that.
It is true.
No, they don't. They will follow up.
See, in fact, what you are saying is true. There are people who they had so many debts. Nobody wants to take out letters of administration, so they know they have passed. Because once you take out the letters of administration, the knife cuts both ways. Now you are also
they know who to follow.
Yes. So people now refuse, and they have to come to court. There's something called a citation. You do a citation so that the court compels one of their beneficiaries to take up that estate.
Interesting.
It happens, yeah.
Now you see, with that, that's the other side of the knife. Now I was talking about the other. If that is what you can do, then surely, why not ensure that the family also benefits from proceeds or assets that this person owns and yet they did not know about?
We are doing it now with the unclaimed financial assets, but in the long run, as we say, the law might need an amendment to compel bank, because they have the details of your next of kin.
They do.
So they should be compelled, once somebody has passed on, that information is declared to their court or their estate or their wife at least, so that then she knows how to proceed from there.
Okay. So then, I mean, we're looking at the end of next week, another 2,500 cases will be off, the load.
Yes.
And so then thereafter, you said that there were some other 6,000 cases that you're looking at making sure they also then, join this. So that means that there will be just, some 900 cases. Of course, the assumption is that more cases will keep coming onto the docket. But then, how have you been able, in terms of personnel, in terms of, and then what does the caseload look around, like the footprint look like around the country, or are these cases centered in Nairobi? What exactly are we looking at then? And then what happens going forward when you're clearly going to have a major reduction in the cases that you have to deal with moving forward?
First of all, we don't see us finishing the cases. We hope we could finish. We hope that one day they will reach a stage where, especially family matters, they're all going for mediation even before they come to court. But we don't see that happening. And because of the administrative processes, they'll still come to us. And as long as people die who have estates, they will continue to come to court. So we don't see a station where we won't have cases. But to give you just a picture in terms of real numbers, the family division in Nairobi, which is our biggest really division in terms of succession matters.
Yes.
A few years ago, which is I think 5 or so years ago, had a caseload in terms of pending cases of 30,000. Now that caseload has gone down to 4,000.
In a span of how many years?
In a span of 4 years.
Wow. Yeah. 26,000 cases.
Isn't it?
Yes.
Big reduction. Many of them were the kind of cases I'm telling you about. People had filed, they hadn't come back, they hadn't, come to conclude those cases, so the cases had piled up. But still, every year, they're getting new cases of 2,200 being filed in the family division. That's in Nairobi. That's just to give you a snapshot of now countrywide what is happening. And the more people get awareness, there's a whole lot of people who have not filed even succession matters. These people sometimes want to sell you land, you look at the title, you see it is somebody, then they say this was my grandfather who died. It means they have not done succession. So those ones are still a whole untapped world out there. So we see like this clearing is good, but we will continue to have more, and we'll be happy to have more, especially if they're just coming to get the proper documentation. They're not fighting, but even if they're fighting, mediation is there waiting for them.
What's the average time that, say, succession takes place? I'm going to give you an example before I'm asking the question. I know we're almost running out of time.
Yeah.
You're good.
I'm good. I come from a place called Muhoroni. It's a settlement scheme.
Yes.
Now, very many of the people who actually own land in Moroni have ancestral homes. And the way it was set up, there was a government trust fund that more or less enabled people to buy that land. So now, some people over time paid off whatever was required through the sale of cane and what have you, and the properties in their name. But there are many others also who just didn't bother. Okay? So that land was there actually is no title per se to that particular piece of land. Now, if one wanted to buy this sort of land, succession has to take place. On average, how long would such a thing take place? Because
or succession.
Yes.
If there's no contest, once you file the documents and everything is ready, we send it to the government printers, and they usually would gazette within a month. So we're talking about now, we're looking at already 6 weeks. After that happens, when you get there's no one who protests. Once it's advertised in the Kenya Gazette, no one comes to say, even me, I have a stake. No one has a problem. We wait for 30 days, then we issue with a grant. So that grant, let's say for administrative purposes, it will take maybe a week or two to process that and for you to collect it. Then now you wait for 6 months and now come up with that application we're talking about for distribution, the one for confirmation. So after 6 months, you'll get a hearing date, depending on the kind of caseload a court has. It would be you'd be able to get a near date or a slightly further one. So we would say for you to now share the estate completely and do everything, you need at least 8 months, if I'm looking at it. All factors being consistent, and given that the Honorable Chief Justice has directed that once a confirmation is filed, whichever caseload we have, if it's not, people are not fighting, within 3 months, it should be finalized. That is now a direction that has been given, that within 3 months, even if parties have agreed, not those cases where we are saying everybody's fighting plus the grandchild and everybody. The ones where they have agreed, those ones will take 3 months. So we will be able to ascertain that within 8, you will be able to get your final confirmation. But you see, once you have the letters of grants, at least the person who is dealing with you knows they're dealing with the right person. And people do this, but it is dangerous. What they do is that they now, based on this letter, they can enter into a sale agreement with you. And that letter takes at most 6 weeks to 2 months.
Now, these times, these are legal times, meaning for such a thing, the law requires that you wait 3 months. For such a thing, the law requires you wait 6 months. That's where these 7-day notice and 21-day notice also come in.
Yes, those ones are legal timelines. Yeah, because you can't shorten the period. You have to wait for that month before. And the idea is to let people, anybody who might have an issue, bring it up. And even those estates we're talking about of tracing, you have time to trace everything and ensure they're all put in the final grant. But even if you leave out some properties, it's not a crisis. You can still come back for rectification. So you'll see maybe in our poster, which we are going to be sharing on next week, there'll be matters set for rectification. Those are somewhere somebody has died, the person who was administering, now they need a new person. So they're coming to say, give us a new person. Or there was a mistake, they left out some properties, they've discovered later, now they include them.
Okay. So now going into next week and then, thereafter, and you're just saying, all right, so as this continues to happen, what should court users know? I mean, sometimes they come and end up in the court system, maybe not necessary. What should they know about then how to, access justice?
Okay. The first thing they should know is that the decisions they're making today will help make sure their succession, when they finally go, is either noisy or it is a peaceful succession. But even if whether it's peaceful or noisy, they should know that it is very simple to file letters of administration, to file an application for succession. So they should feel free to visit our website. They'll see some of the forms that are there, visit our courts and just ask for those forms and take time to fill them. And then seek information from the courts itself. Let them not seek information from, there are people who sometimes are hanging around the courts who are not lawyers to help them. Those ones might take them around and around. They should seek information from the courts. And on our part, the ones which are contested, we are also not saying we are ready to hear them, but we'd prefer they go for mediation. So if they can, let them go for mediation. We are saying, please, it has helped. So far, 3,500 cases have been dealt with.
Yes.
Theirs can be one of them.
Indeed.
So let them accept to go for mediation, give it a chance. Because even if a court decides on one family-related issue today, tomorrow, who is there going to decide? The family will still have to come and decide. Like if you're fighting over a child, access to a child, we can give you today access and say, you have him on Sundays, you have him on Monday.
Yes.
But now tomorrow, if the child is sick in hospital, will you run to the courts? Or it's something you can agree, this is our child, can we see him together?
Yes.
That's the same way with succession. So we are hoping mediation will be taken up very, very embraced by everybody so that we solve those issues.
Honorable Judy Omange is the Registrar on the High Court of Kenya dealing with succession matters. Thank you so much for being in Kenya's biggest conversation today. It'll be interesting to see how these open up in terms of expedited access to justice around the country.
Thank you.
Asante sana.
Thank you.